Judge. Good to see you.
Thank you.
All rise. The Honorables, the presiding Chief Judge and Judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Thank you. Good morning. Welcome to your North Carolina Court of Appeals. My name is Chris Dillon. I'm the presiding judge today. To my right is Judge John Arrowwood. To my left is Judge Michael Stadding. Thank you, Catherine Bryant, for opening court, and we thank Ricky Parks for being here, serving as our marshal. We have one case on the calendar today. It's Chappell versus Webb, and we will hear from the appellant. And let me know if you want to reserve any time for rebuttal.
Thank you, Your Honor. May it please the court. My name is Josh Bennett from Forsyth County Bar. My firm and I represent Shamara Webb and LaDorothy Foreman in this appeal. I would like to reserve 5 minutes for rebuttal, if that's all right. I want to get this point out of the way early. This is a rough case. These are tough facts for my clients, and it's not a case that I think makes anyone feel happy or enjoyable handling and dealing with. We've got two ladies, my clients, who made a series of unfortunate decisions on September 18th, 2020. They spent some time drinking at a party in Lewisburg, North Carolina, and then got in a car to head to Raleigh without a designated driver. At the time of the accident, Ms. Webb was at the wheel of Ms. Foreman's car. The accident ended up killing Miss Susan Renee Chappell, and but not immediately. I think she lasted for a better part of an hour before she got there. So I'm certainly not here today to argue that that accident and that death is not a tragedy. That's not the point, and I don't believe it's the question before the court.
Well, can you remind us what
Yes, sir.
the review is in this case?
Yes, sir. I believe we've got two questions. So the first question is going to be reviewing the size of the compensatory damages award, or I should
And that's
say,
an abuse of discretion standard
I would agree.
of whether or not Judge Sturgis abused her discretion in failing to allow your motion to set aside the verdict. Is that correct?
Yes, sir. And then the second question,
She could have reduced it too. That'd have been part of her discretion too.
she could have. That, I
It's
agree.
all under Rule 59.
I agree.
Okay.
And then the second question, I believe, is reviewed de novo, which is simply, was there enough evidence to submit the evidence of punitive damages against Ms. Foreman?
Well, but didn't your client admit that the defendant Webb was driving the defendant's vehicle with the express knowledge, express consent, and express authorization of defendant Foreman?
Yes. And I believe there's also a statute on that point which sets up prima facie evidence of that 20-71.1.
Well,
However,
that's a judicial admission, isn't it?
I would agree on that point. I think the only pushback I would give is there's and this is actually in a case that was presented by the plaintiff, but it's the Ocean Beach Contractors case, and it says that you ought to only the effect or operation of a stipulation should not be extended by the courts beyond the limits set by the parties or by the law. And so the admission in the answer that Ms. Foreman filed certainly goes to whether Ms. Webb was driving Ms. Foreman's car with her permission. However, and we would cede that likely answers the negligent entrustment claim. However, and this is the big difference, and I think this is maybe the most important thing I'm going to say today, is that admission does not get you to punitives. So there's two big differences there. First, you've got a difference in the standard, right? You've got just preponderance of the evidence to prove negligent entrustment. You've got clear and convincing to prove punitives.
So you have no issue with the actual damages for negligent entrustment?
I think once we've got that admission and the
Do you have a case that says that a judicial admission is not clear and convincing evidence?
I don't have a case that says it is or it isn't, one way or the other.
So you're asking us to make new law here is what you're doing.
I disagree on that, and here's why. The clear and convincing evidence of what is the question, right? So that judicial admission says, all right, Ms. Foreman was okay with Ms. Webb driving her car, I think, but that's as far as you get. It's not just clear and convincing evidence, but it's also different evidence that you need, because for punitives you need willful wanton, right, conduct, or you need gross negligence. And I think that's the problem, is, and they're close, but they're not the same. So, but both require evidence of Ms. Foreman's, what was in Ms. Foreman's head when that occurred, and that's the gap in the evidence. And again, I'm sure you're going to hear that I wasn't in the trial of this matter, which is true, but I'm looking at a cold record like you are. And what I'm looking for when I'm going through that record is, what is the evidence of the moment where Ms. Webb took control of Ms. Foreman's car? And it's not there. The only evidence in this case was put up actually by Ms. Webb. And what she said was, well, when we left Lewisburg, I got in the back of that car. And then the next thing she remembers, there's an accident and she's in the front seat of the car. And so there's a big blank space. I mean, somebody knows the answer to it, but it's not the jury and not the judge at that trial, because it's not there. So what do you...
Now, this isn't the first time that Ms. Foreman has been in the car, her car, allowing Ms. Webb to drive, and in fact, there's a previous DUI where she was actually charged with being an aider and abettor, wasn't she not?
I believe she was. But the issue again is, what happened at the moment where apparently Ms. Webb moved from the back seat to the front seat? We have no evidence about that. We don't know if Ms. Foreman was conscious when that happened.
Well, she admitted that she let her drive with express knowledge, express consent, and express authorization, did she not?
That is what that admission says. I agree. But I don't think that gets you to the knowledge that you need for gross negligence, and because it has to be a conscious and intentional disregard and indifference.
So what knowledge would she had to be proved? That she knew Ms. Webb was drunk?
Yes. And I think that's the issue. Is
she admitted she volunteered? Was there any evidence of what Ms. Webb's blood alcohol level was? That ever admitted at trial?
it was not, but Ms. Webb admitted she was intoxicated. So I don't think that's an issue.
So if I've admitted that I've loaned my car to somebody who's obviously intoxicated, why couldn't the jury infer from that that's wanton and willful and all?
They could, but that's not our facts.
You have the admission, and then you have that Ms. Webb admittedly was drunk. There's evidence. I mean, maybe there's all of.
Well, let's. I'm probably not the one to be posing hypotheticals, but let me pose one. So let's say Ms. Webb, Ms. Foreman gave Ms. Webb her car, and then stayed home all night, and Ms. Webb went out and got drunk. And
but that's not what we have here.
We
What
don't.
the facts we have here is where they were drinking together, had been drinking together all along during this night, had been to a party together, decided they were then going to Raleigh to shoot pool. She admitted that she gave, with knowledge and consent, authorized her to drive the car. That's significantly different than the facts you're posing in your hypothetical.
I agree, but I don't think it's as different as. I think there's two differences. One, again, we are at a clear and convincing evidence standard. There is a difference. It's not beyond a reasonable doubt, but it's not preponderance either. And so.
And was the jury instructed on that?
They were instructed on punitives, and yes,
and they were instructed they had to find by clear and convincing evidence.
Yes, sir.
Okay, and it's the jury to weigh, to believe and disbelieve, whatever. But I'll go with your hypothetical.
Well, and again, I'm not quibbling with the jury's verdict on punitive damages. I'm quibbling with the submission to the jury on punitive damages, and so So yes, when you are having to use the facts that they were at a party together, to then infer from that Ms. Foreman knew, because again, it's not should have known. The negligence is knew or should have known. The punitives is knew, right? There's a great case, Yancey versus Lee, which is a Supreme Court case. It says the difference between ordinary negligence and gross negligence is substantial, and that willful negligence is basically deliberate purpose. And so we are talking about what is in Ms. Foreman's head at that time, and not what should have been in her head. what was actually in her head. And so what we know is they were at a party together, and I agree that probably puts Ms. Foreman in a position to know whether Ms. Webb was intoxicated or not. But there is no evidence whether she actually knew that. And there are many little pieces of evidence.
Well, why can't the jury infer that she knows that from all, as you say, these many little pieces? Why can't the jury infer that?
Because that's preponderance of the evidence. That's not clear and convincing.
What else do you need at that point?
I think you need to put Ms. Foreman on the stand and ask what she knew. I think you need to get the other two people in the car or the people that were at that party.
And they're all her friends, and they deny it. But I mean, so you're telling me if I see somebody drink a bunch of alcohol and they're staggering around, but I get on the stand and say, well, I didn't know they were drunk, the jury can't infer that I'm lying and that I did know that they were drunk?
Well, again, I think they could, but again, that's not our facts. There is no evidence of what and again, I admit it is a razor-thin distinction, but it is a distinction because we don't know that Ms. Foreman saw Ms. Webb stagger around drunk. We don't know that.
Is there not a level of circumstantial evidence that would show that?
I think certainly hypothetically there could be a level of circumstantial evidence, but here
And isn't that for the jury to infer?
It is.
Rather than for what you're telling us, that in order to get punitive damages, you've got to get Ms. Foreman on the stand and say, yeah, I knew she was drunk, and I let her drive my car.
I think that's overstating my argument.
Doesn't seem to me that I'm overstating it much.
Well, then let me see if I can frame it better. No, you would not need an admission, but you would need some evidence, some sort of, not for a jury to determine it. I think that's, and maybe that's where the disagreement is. A judge needs to make a gatekeeping decision at the directed verdict stage about whether clear and convincing evidence has been produced in this case. And I'm not saying
And that's taking all the evidence in the light most favorable to whom?
to the plaintiff, of course. And again, I'm not saying that wasn't possible in this case. I mean, I believe what happened here is you had that judicial admission, and there was a strategic decision made to just not delve too much more into what Ms. Foreman knew or didn't know because you had that admission. Well, that's fine, but if you're...
And did Defendant Webb testify in this case?
She did. Yes, she did.
And she talked about all the alcohol she had consumed?
She did. But what she did not talk about is, again, I think two key things. She did not talk about what Ms. Foreman observed, and not what Ms. Foreman could have observed, but what Ms. Foreman actually observed. And she did not talk about how she came to be driving that car and the moment that she came to be driving that car.
But Ms. Foreman did. She admitted that, yes, I gave the keys, I consented and let her drive the car. And if there's evidence that Ms. Webb was drunk, and if there's evidence that you're drunk and there's evidence that I voluntarily gave you the car, can't the jury infer that I'm there with you and we're in the same car, that I could see you drunk and so therefore I knew?
I think they can infer it to get to preponderance of the evidence to prove negligent entrustment. I don't think they can, when you are at a clear and convincing standard, which again, the case law on that very helpfully defines clear and convincing as something that should fully convince. But it also defines it as clear, cogent evidence. And we are not to clear, cogent evidence, because otherwise, let's look at the alternative too. And I think this is basically what plaintiffs have to argue for, is that in every case where you've got negligent entrustment with a drunk driver, punitives are de facto functionally automatic, right?
Well, here you've had two cases where this same person has let this same person drive her car while the person was drunk. Do we
Correct.
not?
You do. You do. And
So how many times do you have to have before you get to punitives?
well, I guess 2 points there. One, there's case law that says that you look at each entrustment, and poor entrustments in the past do not prove poor entrustments in the future. But
a poor entrustment in the past, in conjunction with an admission that you entrusted this time, are you saying that the fact that she let her drive it before doesn't have anything to do with this punitive?
if she had been, for example, if she had been, so we'd had this prior instance, right? And then instead, this night, Ms. Webb had been cold sober and then got in a car accident because she was doing 45 and a 35. No, I think you could make a pretty good argument that previous entrustment didn't have anything to do with.
But that's not what we have.
Of course, but it does go to show that one does not necessarily affect the other, and so but again, you're getting to the point where there's not just, it's not just that we're on a continuum, right? And if you've got negligent entrustment and then drunk driving, well, you hit punitives. It is a step up. It is a higher level of evidence, and it is different evidence. And if the legislature wanted to just say, well, every time you negligently entrust a car to someone who's been drinking too much, it's punitives, well, they could say that. But they've actually said, thus far, the opposite. They've said you've got to prove substantially more, according to Yancey versus Lee. So
You're saying there was enough evidence from which the jury could infer that Ms. Foreman should have known that Ms. Webb was drunk, because that's what makes the entrustment negligent. Because just handing somebody my keys wouldn't be negligent unless I should have known that person was drunk. That's the actual, that's the compensatory damages. So you're not arguing the compensatory damages?
no, I follow you. I follow your Honor's point about that once you've got the admission of permission and you've got Ms. Webb and Ms. Foreman being in the same place with Ms. Webb admission that she was intoxicated, I do think from a preponderance of the evidence standpoint, again, are you looking, and that is a scintilla of evidence standpoint, can you submit that to the jury or not? I think that probably gets you there. I think that's the issue.
There was enough evidence from which the jury could infer that she at least should have known that Ms. Webb was drunk.
Right. Exactly, but that under a scintilla of evidence standpoint, I think, unfortunately for my clients, that goes to the jury. But that's not the standard that we're working in on punitives. It's not scintilla of evidence standard. It's clear and convincing evidence standard.
And we got you down this road.
Yes, sir.
And away from your first argument, and I'm sorry and I see we're running into your time. So I wanted to get
I want to answer your questions, and so I don't mind at all.
I want to get you.
But it would be good. I've got about 10 minutes to finish out this last point. The other point is just on the size of this award. And as Judge Airwood pointed out, I realize we're working under abuse of discretion standard, which is a high standard. However, I think that this is why this Eshelman case that we have cited is so instructive. I don't know that I think both sides have spilled a lot of ink on sort of the test that Eshelman uses, which is important to my argument, but I also think the most important part is really the lack of deference that Eshelman, the Fourth Circuit, showed to the trial court in that case. And they really followed law from the Supreme Court and the Fourth Circuit that said, well, sure, it is an abuse of discretion standard, but when you see an excessive verdict, you should not hesitate to set it aside. And so it seems to me that one lesson of Eshelman is, at least with very large verdicts like this, there is a reduced deference. But the way you get there is not just, and I think this is a key point, is not just that the verdict is large. It's that the verdict is out of sync with other verdicts. And again, this
The issue before us is not whether I think it's excessive. The issue is whether I think the judge abused her discretion in not concluding it was excessive. Is
I
that
agree.
correct? Okay.
I agree. And again, I think that's the, I think for us, that's probably the most important lesson from Eshelman is that
And Eshelman is a Fourth Circuit case, right?
it is.
Are we bound by that?
Say again?
Are we bound by that?
No, it is certainly, it is instructive, is what I would say. And I will also cede, again, that this is a high standard, but what Eshelman really does, and let's go to its logic, is its test is really, is peel away the layers to see how far we have to go to hit passion and prejudice, because that's really what it is. It's a test to find whether the award was given in passion and prejudice. And so first you look at,
And
well,
is this for the punitive, or is this for the $15 million compensatory award?
it would be for all of it, but I think my focus is on the compensatory award.
So your argument is that passion and prejudice is that $7.5 million for each of this lady's children is too much for her society and companion that they've been denied for the rest of her life. Is that basically your argument?
When you look at other cases in North Carolina, that is correct. And again, I think that's why the Harhouse case that we cite is so instructive, right? I mean, you had very similar facts there.
Well, how much is a mother's love and companion for the rest of your life worth?
Well,
And isn't that a question for the jury?
it is well, I think the problem with that is if you take that logic to its end point, right? It would not matter if this award was 15 billion or 15 trillion, right? You would just say, well, that's the province of the jury. What are you going to do? And there has to be a gatekeeping role. And so if there is no logical endpoint to the amount that a jury can award, then I would posit that test is not the test you should be using. And
But isn't one problem with the other case, Howhurst?
Yeah.
In that case, the jury did not know that they were going to have the opportunity to award punitive damages so the actual damages, as I recall, was a large number. In this case, the jury did know they were going to have the opportunity to award punitive damages. So wouldn't that cut against that when they were acting out of passion and awarding actual damages when they knew they were going to have the opportunity to stick it to them for the punitive damages? So why wouldn't that cut against your argument that they were acting out of passion or whatever and awarding actual damages? When they knew they were going to have the opportunity to punish,
correct.
punitive damages.
Well, and again, I think the punitives is maybe a good point here. Is let's look at the punitives. You've got an award there of $5 million against the driver and $20 million against the owner. That does not seem to logically follow from the facts that the jury found. And again, I think it's just another data
Or
point.
there was not an opportunity for them, was there an opportunity for them to award actual damages other than punitives against the owner? Was that submitted, did they offer?
Other than, I mean,
Other than punitives is what was submitted with respect to the owner, was it not?
compensatory and punitives.
Okay.
Maybe I'm not following.
Okay.
But the compensatory award is against both.
But the jury knew that Ms. Webb went to jail for second-degree murder. Did they know that?
They did.
So, and that's something that plaintiff brings up in their brief. Well, couldn't the jury assess that? Well, she's been punished a bunch. That's why we're going to stick it to the negligent entrustment more to punish because she's not going to jail for that long, I guess, if at all. I don't even know if she got any kind of criminal sentence.
I think I mean,
'Cause the
I
whole
think that
purpose
is,
of
I think that is
punish.
one of one of many reasons that one could devise. I don't have insight on that topic. But
You're in your 5 minutes rebuttal, but I'm going to let you finish this thing, and you still have 5 minutes because we've been asking you questions. So we'll give you, so if you want to wrap up this part.
well,
we'll take a
I
couple-
think I want to wrap it up. Just,
And I want
yes, please.
to get to the point of, I'm looking at the judgment,
Yes, sir.
and I don't see an issue. The issue with respect to to foreman is she liable for punitive damages and how much? Am I missing something on whether, what the compensatory damages to Ms. Foreman was?
Well, the verdict sheet has negligence question for both defendants and then an award.
Okay,
I'm certainly
Okay.
okay with it being interpreted differently, but that's my understanding.
right. I was just looking at the judgment, not the verdict sheet.
Okay. But just to briefly finish this point up, when you use this, looking at other verdicts, which again, this is multiples of other verdicts, and you look at the evidence, which is tough evidence, but it's no tougher than the Har House case. It is no tougher than any other drunk driving case. The multiples that we are of the Har House case lead you to the conclusion that there must be something else at play here, and the only other thing that's left other than evidence is passion and prejudice. And so that's really what Eshelman does, is it peels away the layers and says, well, once we peel those layers away, what are we left with? So I'll leave it at that.
Really quick, did the Har House case, did it have someone loading their car knowing that the other person, potentially knowing that they were impaired? Or did it just have one defendant?
I don't believe it did, but I think Mr. Stradley's probably the expert on that one.
All right, thank you.
Madam Clerk, if we could get the AV turned on. Thank you. May it please the court, David Stradley of the Wake County Bar on behalf of the plaintiffs' appellees. On the evening of September 18, 2020, these defendants, in a haze of Hennessy, beer, and marijuana, took to the roadways of Franklin County, North Carolina. That someone would be hurt or killed was predictable, if not preordained. Likewise, when these two-time DWI offenders, having ripped out the very heart of a family, chose to proceed to trial, the verdict they now attack should surprise no one. As the trial judge found, this compensatory verdict, large as it is, reflects the huge harm inflicted by these defendants, and this punitive damages verdict reflects the need to stop the killing and carnage of innocent people by impaired drivers. Not passion, not prejudice, just devastating loss to this family and to our society. Now, there are essentially two issues here, the Rule 50 motion and the Rule 59 motion. The defendants, by failing to raise issues in the trial court, have waived every single issue here with the exception of the submission of punitive damages against defendant Foreman. And we'll talk about that waiver a little later, but since they haven't waived the one issue, let's talk about that. The defendant's main attack on the giving of the vehicle to defendant, well, they attack the negligent entrustment instruction on two grounds, only one of which they raised in the trial court. The only basis for the directed verdict motion, which of course restricts the scope of the J&OV motion, the only basis for that was that the vehicle was not voluntarily given to defendant Foreman. There was no argument, and you're welcome to consult the record. You can look at the transcript. There was no argument at directed verdict about whether there was sufficient evidence of Ms. Foreman's knowledge of intoxication. That was not argued. The only argument was whether there had to be a voluntary giving. And the fact of the matter is there doesn't have to be a voluntary giving. In Bridges versus Parrish, which is a case from this court, the court noted that entrustment for the purposes of establishing a claim under negligent entrustment requires consent from the defendant, either express or implied, for the third party to use the instrumentality in question. And the Supreme Court in the Swicegood case approved negligent entrustment where a person had given his son permission to drive an automobile. So this notion that there has to be a voluntary giving of the vehicle just finds no support in the case law, despite the fact that the pattern jury instruction contains that language, which appears to be mistaken in this case. And there was, as the judges here, you judges have pointed out, there was a stipulation, a judicial admission of express permission, express consent, and so there was just no question that of entrustment.
Could you address your colleague's argument about the difference between negligence, the evidentiary clear and convincing versus the...
Yes, Your Honor. A judicial admission establishes a fact for all purposes. It is, the case law is clear on that. When there's a judicial admission, it is over. The jury doesn't even get to assess a fact that is subject of a judicial admission. They cannot find otherwise. It is established with metaphysical certainty, not mere clear and convincing evidence. Once something has been judicially admitted, it is done. And in fact, the trial judge can't even admit evidence on the point.
But as I understand your colleague's argument is that there's a higher standard to get to punitive damages, and that it's not just the entrustment, but that you must know that they're drunk when you entrust it and that there's no evidence here. I believe that is his argument. Can you address that?
That is his argument today. That argument was never made in the trial court.
But it was never admitted. The judicial admission didn't say that she knowingly gave the car knowing that she was drunk.
That is correct,
so
Your Honor.
You have to prove that. There has to be some evidence.
And there is ample evidence of that, Your Honor. And let's just walk.
It has to be clear and convincing to get punitive damages on that point.
Yeah, absolutely. And so let's talk about that. And I think okay, there we go. Let's talk about that. We have the admissions, which we have talked about, but what about the evidence of knowledge of being drunk? Well, as Judge Arrowwood pointed out, there's a prior DWI that these two people were involved in. So you can't be shocked that this person that you're going to let drive your car might drive drunk. That piece of knowledge is established. Plus, they started out the night drinking in the car, which is in and of itself a violation of the law in North Carolina. They were drinking alcohol, they were drinking Hennessy, a shot each, on the way to the party. Then Ms. Webb drank, by her own admission, at least 4 beers at the party, where they were only at for an hour and a half or so. And while this was all going on, everybody was standing around in a circle. And further, after the crash, the trooper comes up to the car, and this is the trooper's testimony on the screen, and she noticed Bud Light cans right outside the vehicle, and from walking up, she says, I can smell a strong odor of alcohol before she even stuck her head in the car, and she noticed an open container inside on the floorboard, and again, repeats that it's a strong odor of alcohol. Now, that's the direct evidence that we have, and then we have an expert, Paul Glover, who testifies that Ms. Webb, unchallenged testimony, that Ms. Webb would have shown very obvious signs of intoxication at the time of the crash and within the 15 to 20 minutes prior to the crash. So when you add all that up, it's hard to come to any conclusion other than that she knew. Now, I will forgive my colleague because he and I have the same disadvantage of being civil lawyers. And we don't, frankly, deal with intent very much. But I know you three hear criminal cases all the time. And intent is an issue in many, if not most, if not all, criminal cases. And the fact of the matter is that we establish intent through circumstantial evidence and inference as a matter of course day in and day out. If we did not, the only way anybody would ever be convicted of a specific intent crime is if they got on the witness stand and admitted it, or had admitted it to somebody else and that person came in and talked about it. So the fact of the matter is, North Carolina law draws no distinction between direct evidence and circumstantial evidence. The circumstantial evidence here is insurmountable, and it is hard to reach any conclusion other than that Ms. Foreman knew that Ms. Webb was intoxicated. They had done the DWI dance before. They were drinking together on the way to the party. There was large consumption at the party. There were open containers in the vehicle. I mean, where did those open containers come from if they weren't drinking in the vehicle on the way from the party to the crash scene? And then an expert testifies that it would have been obvious that Ms. not merely impaired, but intoxicated. He drew a distinction between impairment and intoxication, and that she would have been obviously intoxicated. And so, again, to take Judge Arrowwood's example, you can't do any better than that other than getting an admission out of the defendant. So there is ample evidence from which the jury could have concluded by clear and convincing evidence that Ms. Foreman knew that Ms. Webb was drunk at the time of the intoxication.
Can we talk a little bit, I want to talk real briefly about the purpose and difference between compensatory and punitive damages.
Sure.
So let's say I'm a poor man, Judge Stadding's a very wealthy man. If I hit somebody or if he hits somebody, it doesn't matter that I'm poor and he's rich. Whatever damages either one of us causes, that's compensatory. That person's entitled to a verdict for that. So in this case, the jury found that your client's estate was damaged $15 million. That was the actual damage that was suffered. Is that correct?
That is correct, Your Honor, and in fact, it is irrelevant what your ability to pay.
Okay, punitive damages, the purpose is to punish me. Is to punish me, and part of the calculus is what my ability to pay is, and I understand punitive damages is not dischargeable in bankruptcy. Is that correct?
They are not dischargeable in bankruptcy for an impaired driving offense, Your Honor.
Okay, so if you're going to punish me, is how much wealth I have relevant in determining how much punitive damages I should be assessed against me?
It is one of the factors that the jury may consider under Chapter 1D, which the legislature
They
has-
don't have to. You're saying they don't have to.
It is not made as one of the factors the jury may consider.
Was there any evidence as to how wealthy these defendants were?
There was no evidence as to Ms. Foreman's wealth at all. There was evidence that Ms. Webb was essentially destitute. But the fact of the matter is, the jury is instructed by statute that they shall consider the purposes of punitive damages, only one of which is punishing this defendant.
Can the judge, in determining whether or not, in exercising their discretion, determine, this amount of punitive damages is excessive for this poor defendant because, $100,000 would wreck their life? I mean, is that something they could consider?
If we look at the Worthington case, Your Honor, the judge has practically unlimited discretion. The trial judge can certainly consider that, I'm not sure there's any constraint in terms of things that they can consider in determining whether to overturn either a compensatory damages verdict or a punitive damages verdict.
So why wouldn't it be abuse of discretion to say it's excessive to assess a $15 million or $20 million punitive damage award against somebody who's destitute?
Because, again, Your Honor, the jury must consider the purposes of punitive damages, one of which is to deter other people from similar conduct. And in fact, if you read the closing argument, that's one of the things we asked the jury to do in this case, is to send a message to the public, which is 100% appropriate as to punitive damages. We did not make that argument as to compensatory damages. We only made it as to punitive damages, and we asked the jury to send a message that would deter other people and prevent other people from going out and driving drunk so that people would know what the consequences would be. And per the legislature, that's absolutely appropriate, and there's nothing in the statute. And again, this is not a situation where we just have to pull on the threads of common law that come down to us. The legislature has enacted Chapter 1D to govern punitive damages. They came in and said, hey, we don't like the way it is. Here's the way it's going to be going forward. And the legislature specifically said, these are the things that shall be considered, purposes of punitive damages. The defendant's net worth is in the list of things that may be considered, that the jury may consider, but they shall consider the purposes. And we asked the jury to award these punitive damages because of the deterrence purpose of deterring other people from engaging in this kind of conduct. Now,
let's talk a little bit more about punitive damages here. The legislature also sets caps for punitive damages in certain cases, but specifically excluded drunk driving or drunk driving offenses from that. Is that correct?
that is correct, Your Honor. And even if this case had not been excluded from the cap would not have any impact in this case, because the cap is the greater of $250,000 or 3 times the compensatories. And 3 times the compensatories in this case would be $45 million. And there was nothing approaching $45 million in punitive damages in the case. So the cap, I think the cap is instructive in letting us know what the legislature's opinion of drunk driving is. And there are all these things that are subject to the cap. Child sexual abuse, punitive damages is subject to the cap, but not drunk driving. And that speaks pretty loudly about the legislature's view of drunk driving and the need to stop it and deter it, which is exactly why we argued for the punitive damages that we argued.
Is there a constitutional limitation on the amount of punitive damage? Like, has there been a case saying it violates due process? And was that raised in this case?
There was never a due process argument made in the trial court, Your Honor. There may be some amorphous federal constitutional limitation to it, but it wasn't argued. It wasn't argued at the time judgment was entered. And the federal cases that I have seen have been on the order of either 3 or 9 times the compensatory damages. And again, we've got, we're not anywhere close to that.
Well, let's talk about the compensatory damages here. Your colleague argues that they are infected by passion, and how is the trial judge supposed to weigh whether that's the case here? There is no economic loss here. You didn't put on any evidence, and you didn't ask for any economic loss. You've got pain and suffering of your client, the victim, and you've got the loss of companionship of her 2 children and the evidence of what their relationship was. So could you just talk about how,
Sure.
why you contend that $15 million is not excessive with respect to that, or not inflamed with passion?
Well, so I think we have to start at the standard of review to answer that question. And what the Supreme Court has said, first of all, the Supreme Court has categorically rejected this echelon analysis that the defense is putting forward. The Supreme Court looked at the notion of a reasonable range of a verdict. I've got that on the screen from the Worthington case, and rejected.
It's actually not up on our.
I don't know why it should be. I'm not sure if we can get that back going. The Supreme Court said we're not persuaded that the appellate use of a vague test to measure the reasonable range of a given verdict's amount would provide a more effective, consistent, or precise method of determining whether a trial judge has exceeded the bounds of discretion in the grant or denial of a new trial. And the reason for that is that the trial judge, the Supreme Court has said that the trial judge is in the best position to make that determination. The trial judge is an active participant in the trial, sees the evidence, watches the witnesses testify, hears all the testimony, and observes the witnesses and the jurors. It's interesting in this case, particularly on the issue of passion and prejudice, the fact that, unlike most cases that come before this court, you have a memorandum opinion and order from a trial judge, which is rare. But you have Judge Sturgis's order, and you have the transcript of the hearing on the Rule 59 motion. And one thing that Judge Sturgis points out is, the jurors heard all this evidence on Wednesday. They got Thursday off and came back on Friday to hear closing arguments and the charge conference and deliberate. So this is not a situation where they were just all, they had time to digest the evidence and cool off. And so the bottom line is that in the Worthington case, the judge's discretion, as the Supreme Court said, is practically unlimited. And essentially, we just have to defer to the trial judge. Now, if it had been 15 trillion or 15 billion or some number that shocks the conscience, perhaps there would have been something there. But the fact of the matter is, and as we've pointed out, even though the Eshelman analysis does not apply, as we've pointed out, there was a $32 million verdict in an asbestos case in the Middle District, which Judge Catherine Eagles upheld, in which the Fourth Circuit upheld her denial of the Rule 59 motion, and it was of an elderly gentleman, and it was the loss to his family of his relationship. There was an $18 million verdict in Rowan County in 2000 in a nursing home case, which again, it can only be intangible damages. And so this notion that juries just don't do these things, that this verdict is way outside the realm, and citing to the Harhouse case, that's simply not the law of North Carolina. And even if it were the law of North Carolina, there are North Carolina verdicts, setting aside verdicts from elsewhere, there are North Carolina verdicts that far exceed this. And the fact that the Harhouse case was my trial, my case, and Judge Dillon wrote the opinion in that case. The fact that I didn't do a very good job in Harhouse should not penalize my clients in this case. The bottom line is that the trial judge heard everything, and you can read the transcripts of the hearing, gave very thoughtful consideration to the motions, and decided that $15 million was not too much for the loss of a mother's love and companionship for the rest of your life. And this was a young mother. This woman was in her late 40s when she passed and was very close with both of her adult children, and she endured a horrible, horrible death away from her family that she loved. She was trapped in the vehicle for 30 minutes with multiple fractures and struggling for breath, one of the things that is most terrifying to a human, to be unable to get her breath. And then she had to be extracted while, with these multiple fractures, she had to be picked up and taken out of the car. So it was horrible. And I will suggest this to you. One reason that the verdict is what it is there was no suggestion from the defense of a different number. The defense didn't say, well, ladies and gentlemen, 15 million is just too much. And interestingly, that's exactly what we asked for. You can look at the transcript. We gave the jury 15 reasons to give $15 million, and that's what they did. And so if this were passion or prejudice, one might think that they would have gone off on some tangent of their own and given some additional money or picked some number out of the sky. But in fact, they did exactly what they were asked to do on compensatory damages. And there was no competing...
Is there any argument, and because I haven't read what your 15 reasons were that you gave to the jury, is there any argument that the defense has made that any of the 15 reasons you gave were inappropriate?
Your Honor, there was, and which sort of brings us back to the waiver full circle. There was no argument during no objection during opening statement. There was no objection during closing argument, and to my recollection, there was no objection that was unsustained to our evidence during the trial. there was simply nothing that they lost, and I think that's why you're hearing the arguments that my colleague is having to make today, is there simply were no opportunities for error in the case because there were no objections, at least none that were lost, and there were none in opening and none in closing. And so this notion that you know, we said these horrible things to whip up the jury in opening, where was the objection? If they were so, if these statements were so horrible, where was the objection? If there was stuff said in closing, where was the objection? And you know, it simply doesn't exist. Talking about these statements, the two statements that are now pointed to, again, weren't pointed to at the time, weren't pointed to in any argument in the trial court. This is all new. This is, as I've said before, this is the Pony Express method of argument. Ride one argument till it falls over dead and then jump off of that one and jump on another one and take on off. This whole notion that there was anything improper in closing or opening, that's a new argument on appeal. Rule 10 says you can't do that. But the fact of the matter is, we had a statistic about the number of people killed by drunk drivers every year. That goes directly to proximate cause, goes directly to foreseeability. They didn't like some of one word they didn't like in opening statement, and they point to three words or three phrases as their sole evidence of passion and prejudice in this case. A statistic about the number of people killed by drunk drivers, the word slaughtered, which means to kill in a violent manner, which is exactly what we have here, and then the notion to speak loudly with the verdict, which was restricted 100%. If you read the transcript, this is a little misleading in the briefing, if you read the transcript, that was solely on punitive damages. And again, the defense could have done, as the defense did in the Harhouse case, could have sought a bifurcated trial. And in fact, they did move for a bifurcated trial and then withdrew the motion prior to trial. So the defense decided that that the jury was going to hear both of these things at the same time, perhaps precisely for the reason that Judge Dillon suggests, which is that perhaps that would keep the compensatory damage verdict down if the jury knew they were going to have the opportunity to punish, and then perhaps try to leverage some higher burden of proof on punitive damages. I don't know why that strategic decision was made, but it was. And so one simply should not be heard to complain that there was an argument in closing that was explicitly restricted to punitive damages, not made during the compensatory phase or during the part of the argument about compensatory damages.
Now, was the evidence about the number of people killed by drunk drivers,
Yes.
where was that? Was that evidence or an argument in the punitive, or was that in the compensatory part of the case?
That was opening statement, Your Honor, which would have applied to both phases of the case, and it previewed evidence from the investigating state trooper who testified to that. It's a publication of the Department of Motor Vehicles, North Carolina Crash Facts, and it lists the number of fatalities annually in driving while impaired crashes. And our argument simply was and is that the fact that lots of people are killed by drunk driving accidents every year means it is very foreseeable, which is an element of our case, and which Defendant Foreman denied in her answer. She denied that this was she denied proximate cause. That we have to show it's foreseeable, and one way we show it's foreseeable is, hey, this happens a lot when people drink and drive, and you know it, and therefore you should know that it's dangerous. And in fact, Ms. Webb admitted in her testimony that she did know it was dangerous, but that is perfectly admissible evidence, which again, there was no objection when it was said in opening, and there was no objection to it coming in when it was introduced by the trooper. So,
What, if anything, are we to make of the difference in the punitives between the driver and the owner?
you know, I think that's one reason we give a lot of deference to juries and we give a lot of deference to trial judges. But as Judge Dillon pointed out, the evidence was that Ms. Webb was serving I think it was like a 13-year sentence for second-degree murder in the case. She had pled guilty to second-degree murder and was serving a sentence. She also testified and never denied that the crash was her fault. And she, to some extent, managed to muster an apology on the stand, although I don't think it was very convincing to anybody. But the fact of the matter is, Ms. Webb had accepted responsibility and was paying a heavy price of 13 years in prison for her bad decisions. Ms. Foreman, on the other hand, sat at counsel table the entire time, smirking, and never accepted one iota of responsibility for this at all. Never accepted any responsibility whatsoever and was never punished. In fact, she was charged with DWI and that was dismissed. And so she had no punishment whatsoever. And so that could easily explain the discrepancy between the punitive damages as regards the driver and the owner in the case. My time is dwindling, but so let me just sum it up. Practically every issue the defense raises was waived by failure to bring it up in the trial court. But the bottom line is this. There was ample evidence, whether it is preponderance, clear and convincing, whatever standard one wants to arrive at, beyond a reasonable doubt. I mean, we convict people day in and day out on circumstantial evidence from which a jury draws inference beyond a reasonable doubt about intent and therefore about knowledge. And we have a mountain of circumstantial evidence from which a jury could infer that Ms. Foreman knew that Ms. Webb was drunk, even if that issue had not been waived by failing to raise it in the trial court. And as regards the size of the verdict, Worthington versus Bynum, the Supreme Court has simply said it is complete deference to the trial court unless the number shocks the conscience. And I don't think I don't even think the defense has suggested that this shocks the conscience. They just say it was out of line with some other verdicts. But the fact of the matter is, as we've shown you in our briefs, it's not out of line with all other verdicts. It's a big verdict. I'm going to be the last person to say that it's not. But it doesn't shock the conscience, particularly given the loss here to this family and the fact that we were dealing with a two-time drunk driver combo here. So for those reasons, we believe the order of the trial court should be affirmed in all respects.
Thank you.
Thank you, Your Honors. A couple quick points. Practically unlimited discretion in using the definition that I think the plaintiff would like you to use basically eats the rule. Practically unlimited is another way to say limited. This is a exceptional case. I think the fact that at worst, for our arguments, we are the third largest wrongful death verdict in the history of jurisprudence in North Carolina says a lot. And that
Were the other two sustained or were they set aside?
the asbestos verdict that he discussed was sustained by the Fourth Circuit, although I would also say it was pre-Eshelman. So that may have had some effect there. But again, even in a worst case scenario, there's still only two in the history of the state that are larger than this. So this.
Is it true, is it correct, not true, is it correct that they asked for $15 million and whoever tried the case for plaintiffs did not push back and give any other verdict or say that's?
That's my read of the record.
I know you didn't try the case.
Well, of course, but that is my read of the record. But I would, and this maybe takes me to my last point, this issue of not bringing up objections at trial. The analysis is simply, is this verdict a result of passion and prejudice? Whether the statement was objected to at trial is irrelevant to that analysis. You can't object to passion and prejudice before the verdict comes down. So
Object, though, to the argument, could you not?
you absolutely could, but if your argument was overruled, you could still, it doesn't affect your ability to later say, if the jury heard something, if an event occurred at trial that affected them, and you can determine from that their verdict was other than based on the evidence, which is of course our argument, then whether something was specifically objected to at trial still means that their verdict was arrived to.
And again, the question before us is
Yes.
not whether I think it was
Of course.
done by passion, but whether I think it was an abuse of discretion for Judge Sturgis not to make that
Right.
determination. Okay.
I agree, and I'll end on that's how the Eshelman case is instructive, not binding, but instructive to you, Your Honors, because it says when you've got a large verdict like this that is out of sync with others' verdicts in the state, then you don't have to give the kind of deference that you normally would, and you can exercise your power here to correct the wrong below. So I'll leave on that.
One
Appreciate it.
quick question.
Of course.
Does Eshelman discuss the Worthington language from the Supreme Court?
Oof, I don't believe it does.
Thank you.
Thank you for your arguments. We will take it under advisement.
All rise. The Court of Appeals is adjourned.
Hey, thanks, David. Nice work. All right, you too. Your side was a lot more popular than mine was.